right, and our next case is Lisa ZELNICK versus Marilyn EAKIN and A&A Real Property.
Cleared everything up, didn't it?
I don't know what do you agree or disagree.
The presiding judge should have the other members of the panel under control.
I thought you guys need a lot of help. So.
Good morning, Your Honors. I'm Alec Russell, and I'm here with my law partner, Rex Mal, and we represent the appellant, Lisa ZELNICK. May it please the Court? Your Honors.
5 minutes all right for you on the rebuttal?
Yeah, that'll be
All right.
fine. Thank
Go
you,
ahead.
Your Honor.
Thank you.
Florida Statute 732.401 sub 1 controlled the descent of decedent's homestead in this case. The statute provides that if not devised as authorized by law and the Constitution, homestead shall descend in the same manner as other intestate property. But if the decedent is survived by a spouse and one or more descendants, as in the case here, the surviving spouse shall take a life estate in the homestead with a vested remainder to the descendants in being at the time of the decedent's death per stirpes. The only devise authorized by law and the Constitution is a devise in fee simple directly to the surviving spouse.
But that assumes that the property isn't entirety's property. Isn't the threshold question here whether or not the property, the homestead, we'll call it the homestead. I guess there's some issue as to whether it's homestead or not. Let's just call it the property. Whether the property was entirety's property, or whether or not the conveyance to the trust, when the trust says divide everything into 2 shares, whether that terminated the entirety's status.
That is a threshold question, Your Honor, and our position is that the conveyance into the homestead did in fact terminate the tenancy by the entireties. Tenancy by the entireties can be severed in 3 ways, essentially: death, divorce, or an agreement or an intention to do so carried out by the husband and wife. A couple may choose to terminate their tenancy by the entireties.
And you're focusing on number 3, this agreement of the parties.
Of course.
Okay, so the question that I have for you is, when the trust says, no matter how the property was acquired or titled, to divide it into 2 shares.
Yes, Your Honor.
Is that merely a bookkeeping entry? In other words, you know, from an accounting standpoint, we want you to keep 2 columns, or is that an actual conveyance that split it? And how are we supposed to decide which one it is?
It's the latter, and it's because
Explain
that's
why you think that's more logical than it was just a bookkeeping entry.
That is more logical because, well, for example, in the answer brief filed by MARILYN EAKIN, they raised the argument that, well, the property was divided that way, all their assets were divided that way to avoid paying estate taxes. It was for tax planning purposes. Well, if the EAKINs sought to avoid paying taxes, they had to. Not to avoid paying taxes, but to limit their tax consequence of their estate plan. They had to divide their property into separate shares in that way, without a right of survivorship, by the way, in order to avoid that tax consequence. The problem...
Is there any evidence in the record? I mean, I understand how a credit shelter trust works, and I understand the problems created by entirety's property because it automatically goes to the other spouse and can't be used to fund a credit shelter trust.
Exactly.
The question that I have is there any evidence in the record as to how this property was accounted for on the 706, if there was a 706 filed?
There is not, Your Honor.
Okay.
Okay. The problem, returning to that issue, the problem with the EAKIN's estate plan in this case, or their tax planning, was that they failed to execute waivers of homestead. Because homestead rights were not waived in this case, as they ordinarily would be with this type of tax planning in one's trust or will, the only permissible devise of the homestead was to the surviving spouse. And the attempted devise to the subtrusts in this case violated the Constitution, and therefore decedent's homestead descended pursuant to 732.401. And the court didn't make any finding that the homestead or decedent's homestead was devised to the surviving spouse in this case. In fact, the court carefully avoids it, refers to it as a purported devise or distribution, and then says that the decedent's homestead was disposed through the trust, although inartfully. And the court bases that finding on an underlying finding that, well, she's the trustee and she was a beneficiary, and therefore decedent's homestead was at her disposal as trustee and beneficiary after Mr. EAKIN died. Again, that's not sufficient. It has to be a devise in fee simple to avoid the operation of 732.401.
If we agree with your position, then is the net result that Mrs. EAKIN, the surviving spouse, kept her half of the homestead, kept her half of the property,
Yes.
and had a life estate in the remaining half, which she was able to convey to A&A, and she
Yes.
was able to convey her half. So what we're really fighting about is the value of, or not the value, but the rights to the vested remainder in the half.
Precisely, Your Honor.
You're not challenging the conveyance of her half or her life estate.
We're not, Your Honor, and that goes to the Chapman decision that we cited in our brief that talks about the effect of the deed to A&A. And under modern conveyance, and there are actually a few cases out there that address this issue and say that where a life tenant purports to convey real estate in fee simple, the conveyance is not void, even though it's defective, it's not void, it suffices to convey the lesser interest, the life estate, still conditioned on the grantor's life.
Both sides seem to agree that the parties continued to treat the homestead property as homestead property.
That was stipulated to at summary judgment, Your Honor.
Did both parties continue to treat the property as though it were still a tenancy by the entireties? In other words, could either party alienate the property without permission from the other or cooperation from the other? Under the joint, they were joint trustees, correct?
Yes, Your Honor.
Did they have to act jointly on any transaction?
That's not an issue that we looked at, Your Honor. It's in the trust. I'm sure I could pull that up and look at it, but off the top of my head, I'm sorry, I'm not able to answer
That's
it.
fine, that's fine. But I mean, is there, it's not a circumstance where one went into a trust that only went one direction and one went into a different trust that went a completely different direction?
No, Your Honor. It went into a single trust that divided not only the homestead, but all trust assets into separate equal shares, one for each settlor. So to that extent, no, they did not continue to treat the property as if it were owned by tenancy by the entireties. But of course, these people, like other laypersons, probably had no concept of what a tenancy by the entireties even was. Back to the trial court's finding that the property was disposed through the trust to MARILYN EAKIN, that's also an erroneous finding. At the moment of William EAKIN's death, the decedent's homestead ceased to be an asset of the trust and descended pursuant to 732.401. So it was not at Mrs. EAKIN's disposal as either a trustee or a beneficiary at that time. And we cite the example of Aronson versus Aronson, where Hillard Aronson deeded his homestead into a trust. that provided that when he died, his spouse would take a life estate with a remainder to his two sons, and his two sons also became successor trustees. And after his death, the widow and the sons got into some sort of a dispute that culminated with the sons announcing a plan to sell the homestead under their authority as trustees, because that's where the homestead had gone. The widow filed suit, arguing that 732.401 controlled the descent of the homestead and that she took a life estate outside of the trust. So the trustees had no power or authority over the homestead. The district court agreed, and the court said, because the Key Biscayne condominium was Hillard's homestead and because his wife Doreen survived him, the condominium was not subject to disposition through the trust. At the moment of Hillard's death, his homestead property passed outside of probate in a twinkle of an eye, as it were, to his wife for life, and thereafter to his surviving sons, James and Jonathan per stirpes, and then it cites the statute. From that moment forward, the trustees had no power or authority with respect to the former marital home. The same thing happened here. When the decedent died, his homestead immediately passed with a life estate to MARILYN EAKIN and a vested remainder to his children. It was no longer a trust asset. She had no power, no trustee would have. Ms. EAKIN, had she stepped aside and a successor trustee had taken over, certainly we wouldn't be arguing that a successor trustee had the ability to control the disposition of the homestead.
But then again, that's predicated upon the question of whether or not the tenancy by the entireties was terminated on the conveyance to the trust.
Yes, it is, Your Honor.
So
that is a threshold question.
Yeah, you would agree that if the tenancy by the entireties was not terminated, then it's not good for you. On the other hand,
that's correct, Your Honor.
If it was terminated, you've got a much stronger position.
That's correct, Your Honor. And the only record evidence before this court as to whether the tenancy by the entireties was terminated is the conveyance into this trust and the language of the trust that says that the homestead and all other property shall for all purposes of this trust be equally divided into two separate equal shares, one for each set lore. Such ownership is completely contrary to a tenancy by the entireties. As example, we cite the case of Kowalski versus Rosenbaum, where the second district noted that a unique aspect of a tenancy by the entirety is that each spouse is seized of the whole or the entirety and not of a share, a moiety, or a divisible part. It's exactly the opposite of what this trust provides. It provides for a share, a moiety, or a divisible part, where Mr. and Mrs. EAKIN were no longer seized of the whole or the entireties of the property. And I don't mean to speak down, I'm sure your honors understand how that works. And again, the fact that the EAKINs may have, there's no actual evidence as to what their thought process was as far as their tax planning, but assuming for the sake of argument that they did divide their property into separate equal shares for tax planning purposes, this is simply one consequence of it because there wasn't a waiver of homestead rights. The appellees have argued that the trustee had the discretion to either place decedent's homestead into the survivor's trust or into the bypass trust. That discretion does not help their case, though. The disposition of homestead cannot be subject to the discretionary decision-making of a trustee or of anyone else. Only the decedent had the power to direct the disposition of the homestead, and his only options were two. One, he could devise the homestead in fee simple to his spouse, or two, he could allow decedent's homestead to descend by operation of 732.401 sub 1. When a person owning homestead dies, leaving a spouse and any descendants of any age, Those are the only two possible outcomes. It's either devised in fee simple to the surviving spouse, or it descends by operation of the statute. The purported devise in this case, even if we assume that the decedent's homestead remained in the trust, that devise still fails because the trust directs the disposition, the further disposition of the homestead to one of the bypass trusts, not to the surviving spouse. In their answer briefs, the appellees rely on the estate of Donovan to say, well, in this case, the court said that a devise into a trust rather than directly to the surviving spouse was tantamount to a devise to the surviving spouse. But that case is eminently distinguishable. The decedent in that case had a will and a trust, both of which left his entire estate to his surviving spouse. She was, the wife was not only the sole trustee, but also the sole beneficiary. And the trust was set to terminate within 45 days after his death, and at the sole discretion of the surviving spouse. So she could terminate the trust immediately upon her husband's death and take ownership in fee simple of the homestead. Therefore, the court applied the merger doctrine because the legal and equitable estates had merged into a single person, being the surviving spouse. In this case, MARILYN EAKIN is not the sole beneficiary of the trust. She's one of 5. Therefore, the legal and equitable estates have not merged in this case. Donovan is inapplicable, and even if decedent's homestead remained in the trust, it wasn't devised to the surviving spouse. Additionally, again, if MARILYN EAKIN had resigned or become incapacitated, a successor trustee would have stepped in, and certainly they wouldn't be arguing that decedent's homestead had been devised to a successor trustee merely because that successor trustee has the ability to sell or encumber trust property. And I think I will sit now. I'm into my rebuttal time, so unless the court has any questions at the moment.
All right.
May it please the court. My name is Scott Krasny, and I represent MARILYN EAKIN individually and as trustee of the EAKIN Family Trust. And MARILYN is sitting right here. And so I wanted you to have an opportunity to see her. She's not passed away. She's alive. We're talking about real people as opposed to life estates that might terminate. Also, the co-appellee, A&A Development, represented by Tracy Adams, we've agreed to split our appellee time. I'm going to take 13 minutes, and she's going to take 7. And primarily, the issue that she will be covering is the statute of limitations and latches argument in this case, because this property has been sold. It's been sold for 18 years. Well, actually, 17, in 2007.
Let me ask this. We understand that.
Okay.
But if the property retained its entirety's nature, then the tax shelter fails, does it not?
No, not necessarily, Judge, and especially it's important to look at the overall trust. I mean, I recognize the appellants focused on this separate share issue, and keep in mind when this trust was drafted.
So, I'm focused on that too.
It was drafted in 1989, and the federal estate tax laws were significantly different than they are now. Now you can leave 11 point.
We understand
Right.
that the result is different now, but that's
Correct.
not what we're dealing with.
In terms of the federal estate tax issue, in terms of it dividing it into separate shares, it was a pick and choose pecuniary formula. It didn't require any particular asset, but it's important to
Well,
look
do you agree, though, that you can't fund a credit shelter trust with assets that are owned by the entireties or survivorship?
Well, in terms of the post-death distribution, MARILYN EAKIN as trustee, based on advice of her counsel, funded the bypass trust with this homestead property.
I understand, and I'm not talking about whether or not it's, well, for purposes of federal estate tax purpose, the whole idea of a credit shelter trust is that you keep certain assets out of the estate of the surviving spouse, out of their control. And if that property retained its survivorship status, then it automatically went to her. She had control, and so that should have been included in her estate whenever she ultimately passes, which I hope isn't anytime soon. So But, I mean, don't you agree that entirety's property can't be used to fund a credit shelter trust?
In terms of the, and again, it's important to look at the rest of the terms of this trust related to homestead.
Because that's a fundamental issue, at least from my perspective.
In terms of tenancy by the entirety's property, there's all sorts of ways to use tenancy by the entirety's property to fund a credit shelter trust if a spouse either waives an interest or directs it as trustee into that trust. And so,
What's your authority for that position?
in what?
For the, either waives it, there was no waiver
There was no
here.
waiver in this case.
Or-
There was no outright waiver. She used at her discretion as trustee to fund it into the bypass trust. That's correct.
I still don't understand, though. It seems to me that the whole idea of a bypass trust is you can't have the surviving spouse control the property.
Well, under the terms of the trust, and it specifically references in the trust homestead property. There's a specific reference in the trust related to homestead property. And it's referenced in my brief, but basically it transferred all of their property into the trust, and then within that property, in the terms of the trust, they reserved to the survivor. So the settlers, they were co-settlers of this trust. It was a co-trust. They were co-trustees. They both contributed assets, including their homestead. When they deeded the house into the trust, they reserved all the rights to transfer, to control, to acquire, to lease, to mortgage. And basically, in the settlers' powers, it reserves to the settlers or the survivor of them the right to transfer property, to amend property, to take property in, to take property out. In exercising that trust, the trust was supposed to be for the primary benefit of the spouse and their survivor. It said that they could sell and buy and transfer real property, including homestead property. It indicated that, and there was a specific reference, the surviving spouse shall not be required to pay rent. They can use the home, and upon their direction have the trustees sell such house and reinvest the proceeds for the surviving, as the surviving spouse so directs.
What is the effect of the language in the beginning of the trust that says no matter how the property was previously titled or acquired, everything that we're putting into the trust is to be divided into two shares?
I think it's exactly what you said, which was basically a bookkeeping issue, in terms of the trying to make sure that each spouse
That
utilizes.
sounds like we want our cake and be able to eat it too argument. You make a choice. You make a choice whether you're going to, if you're going to take property that is owned by the entireties and you want to utilize it, because you don't have to utilize that property to fund the shelter. You could use other property if there were sufficient other property to fund that trust or the shelter. But you make a decision that I'm going to use this property to fund the shelter. I'm going to get the benefit of that in terms of estate taxation, but there are consequences to that.
Well, I guess the question.
And you're wanting to avoid the consequences, but get the benefit of the tax savings.
No, I think there's a different issue, Judge, because the issue, and especially in the argument that they're making, they're saying in the blink of an eye, the minute that Mr. EAKIN passed away, that this property, life estate and a half, remainder to lineal descendants. In other words, completely ignore the provisions related to the trust as this homestead that was their homestead.
You can't fund this tax shelter with entirety's property.
Regardless of the tax issue, and I understand that you're focused on the tax issue in terms of whether or not that this survivorship interest existed. Their argument in terms of the separate shares and in terms of the homestead property 732-4011 is at the moment that he died, this co-owned trust, their homestead property that they had owned together, was now by operation of law, and the only person.
I need, if you all are going to confer, you got to do it a little.
Counsel?
If you're going to confer, it's got to be a little more discreet and a little quieter than that. Okay.
They're arguing basically that 732.4011, by operation of law, the moment that he passed away, there was no choice to fund this into the credit shelter trust. There was no choice of anything at that point. That by operation of law, this provision of the Florida Homestead Law, which is intended only to...
I'm not sure that it doesn't occur at the moment that the trust is established.
that 732-4011 would control the disposition?
You're taking entirety's property, you're putting it into a trust for purposes of this tax shelter.
Well,
And you know at the moment that you create that trust, that it's done for the purposes of this tax shelter, and you know when you create the tax shelter, or you should know, that you can't use entirety's property to fund that.
Judge, I think that, again, we're looking at it from a 2019 periscope versus a 1988, 1989 when this trust was created.
I get that.
I realize, and the problem is co-trust, joint trust, were very common. I mean, they're not as common anymore, especially if you're doing estate planning now. But co-trusts were very common. People say you're going to avoid probate, and we're going to put it in there, we're going to do all that stuff. So when their co-owned homestead property went into that trust, and it was there for 10 years. They lived, until he passed away. And what they're saying, their argument on 732-401 is forget the tax, their tax provision is wagging the dog, but what they're saying is because of that tax provision, as a matter of law, 732.401, which is only intended to benefit surviving spouses and minor children, should now somehow be used to benefit the adult lineal descendants.
What has
of
been
one of
used
the-
in the past to benefit the adult, when there was only a surviving spouse and adults, they upheld that as well. Treated it as homestead with a life estate only.
I'm sorry, Judge, I missed the...
But there are cases involving spouse and adult children where they've invoked that successfully, correct?
Well, let's take the Aronson case, the one that they referenced. The Aronson case actually did a benefit to the surviving spouse. I mean, if you read that case, what happened is the wife was living in the house, and the two boys, the two adult lineal descendants, announced to the wife, we're going to sell the house.
Right.
So the court actually protected the surviving spouse by granting the life estate with the remainder to prevent the trustees from selling the property. This trust is completely different, and as you know, Judge Cohen, I know you had a case, Brown versus Miller. It was a $7 million trust case. Judge Evander wrote the opinion where you had to look at the terms of the trust and the overall intent of the trust. The overall intent of the trust was never to prevent the surviving spouse from living in the house, selling the house, mortgaging the house, making any decisions with respect to it. It was their house together. And so I understand in terms of, well, how do I fund a credit shelter trust? With that, taking their position, there would be no ability to fund the credit shelter trust. That homestead would have vested as by operation of law immediately upon his death.
When you fund it with other assets,
And so, again, that wasn't hardwired into a bypass trust. That was an action she took post-death. After death, when that was funded, the credit shelter trust, 6 years go by, the property is then sold, 2007, nobody does anything. Now we're in 2016 and a lawsuit gets filed. So in terms of the overall writing intent of the restriction on devise in 732-401, the intent is to protect surviving spouses and minor children. And what they're actually asking you to do is to beat MARILYN EAKIN with this and indicate to her that she did not have the authority to handle what was her own homestead property.
What's the consequence of her not being the sole beneficiary?
Well, she is the sole, during her life, she's the sole, she, as the trustee right now, she's the only one entitled to benefits from that trust. And
Well, but she has a fiduciary duty to the remainderman.
correct, and in that trust, Judge, and I pointed out in the trust, she's got all the right to income, she can evade principal, she's got a 5 and 5 power, she has the power to invest in basically all the bundle of rights. Again,
Subject to, it's to maintain her in the lifestyle, et cetera. She can't just decide she's going to go to Vegas and gamble it away because she has to respect the rights of the remainderman.
well, fortunately, we don't have that problem. There's 3 other counts of their complaint that they're arguing about and other things that they're alleging that MARILYN EAKIN did that are not at issue here. The issue here is really only respect to this homestead property. And whether, as of the moment of his death, she was somehow divested of that interest in favor of his lineal descendants. I would dare say they probably, had MARILYN EAKIN died first, they would probably not be taking the same position.
Well, your argument essentially then comes down to this was just a bookkeeping entry, not a conveyance, when we talked about dividing it into 2 shares.
They reserve,
But there's no evidence in the record that I could find to support that, in the sense that there's no evidence of what the records of the trust account, how they accounted for it. how the 706 was filed, if they're assuming that there was one, you know, you wouldn't do a credit shelter trust if you didn't have to file an estate tax return. How it was accounted there, I mean, we don't really know. The record is devoid of any evidence as to how it was accounted for. I mean, all we've got is the cold words of the trust.
Well, not only the cold words of the trust, we've got the statute, we've got the Constitution, and lots of law that interpret the liberally, that this provision of the Florida Constitution is to be liberally construed in favor of surviving spouses. And so, again, all of the stuff that happened on the 706 and all of it, whatever, and again, I don't even believe there was a 706 file, but even to the extent that there was, what they're saying is, as of the moment of death, it doesn't matter what happened. The bypass trust, they're saying as a matter of law, the minute they put this, that he passed away, she was now somehow divested of that, which I think flies in the face of what the provisions of the Florida Constitution, which are intended to protect surviving spouses, the case law, which liberally construes it for the benefit of the protection of a surviving spouse, not to punish the surviving spouse, and especially in a co-trust like this.
Well, it's not a punishment. I mean, you know, there is an idea of being, you know, falling on your own sword. I mean, they're the ones that wrote it, and I understand that their counsel wrote it, but, you know, if it's a problem of their own making.
Well, again, there would be normally, you'd have no constitutional restriction on your ability to devise property, that's a constitutionally protected right. And so this reasonable restriction, the question is the reasonable restriction on your ability to convey property and to protect surviving spouses and minor children should be now used to punish her. So I'm going to actually defer the rest of my time to opposing counsel, to the other appellee.
Good morning. May it please the court. Tracy Adams on behalf of A&A Real Property Development.
Ms. Adams, why should we address the issue of latches or anything else when the trial court didn't address that? And aren't those inherently factual issues that can't really effectively be resolved on this record?
Well, the trial court never reached the issue because it determined that the property was validly devised to the surviving spouse.
And so if we disagree with that, I understand your fallback position is, okay, well, they lose on statute of limitations or on latches.
Correct.
But aren't those inherent?
Purchaser.
I'm sorry?
And bona fide purchaser.
But aren't those inherently factual determinations? I mean, we don't know, for example, on statute of limitations when she knew or should have known of the problem, when the meter started to run, latches, kind of a, you know, another concept.
I would specifically address the statute 95.22, which is a 7-year, it's very specific, it's a 7-year limitations period.
Were those pled as affirmative defenses? That you plead latches and the statute of limitations as affirmative defenses?
Yes, and bona fide purchaser, all three.
As opposed to a motion to dismiss, you're telling us that you pled it as an affirmative defense?
They were raised in the motion to dismiss as well.
Was it pled as an affirmative defense?
Yes, Your Honor. And the 95.22.
Sure of that?
I wrote the answer and the affirmative defenses, so to the best of my recollection, yes, they were raised.
All right.
The 7-year statute of limitations is specific when property of a decedent is conveyed by one of the heirs. Any person has 7 years to basically place a claim on that property. And that's the exact situation we have. We have decedent William EAKIN, we have surviving spouse MARILYN EAKIN conveying property to A&A in 2007. That was recorded in July of 2007, that conveyance. From that moment forward, first of all, that's actual notice to Ms. ZELNICK that the conveyance occurred, the recording, and she had 7 years from that time to raise her claim. Not only did she not do it in 7 years, she never petitioned for a determination of homestead to raise her claim. She waited 10 years, almost 10 years, to bring this issue up. And that's why, regardless of the determination of whether or not this homestead was validly devised to the surviving spouse, which we believe it was, the limitations period has run.
Let me ask, does the bona fide purchaser defense require a claim and interest in property by virtue of an unrecorded deed or mortgage?
In the statute, it says, or any interest therein. So that was the argument that appellant made, is that the bona fide purchaser didn't apply because there was no unrecorded deed. And it's our position that there is no interest of record by Mrs. Zelnick, which she could have put on the record, as I said, by petitioning the probate court. That would be the simple thing back in 2001 when her father died. If she thought she had a remainder interest in that property, she should have petitioned the court for a determination of homestead. And also, appellant cites to a publication of the Florida Bar, litigation under the probate code, and that the section that they quote actually implores the personal representative to do such a thing because of the inherent nature of homestead and the potential for title defects. So under bona fide purchaser, we looked at the record, we saw the deed into the trust, we saw the deed into Marilyn and William, tenants by the entireties. We saw the deed into the trust, which was recorded, had the language that this is for the purpose of, that the surviving spouse can do basically whatever she or he wants with this. Then we have the devise from the trustee out of the revocable trust into the bypass trust, which also retains the right for the trustee to sell the property. We have the language in the trust itself, which stated that no person dealing with the trustee had to investigate any further the authority of
Right,
the
and
trustee.
Your time's expired. You want to wrap it up in about 10 seconds here?
All right. So based on the 7-year statute of limitations, based on the record that A&A had before them, the laches argument that this came way too late, equitably speaking, and the fact that the trust itself told A&A, you don't have to look any further.
Okay, thank you.
The conveyance into A&A should be confirmed as valid. Thank you.
Initially, I want to point out one other point with regard to the tenancy by the entireties. Your Honors asked if it might have been a bookkeeping function or the like, which we opposed, of course. And I talked about the unique aspect of a tenancy by the entireties where each spouse is seized of the whole or the entirety of the property. Another unique aspect of a tenancy by the entireties is that it must be owned by a husband and wife. In this case, the homestead was conveyed into a trust. It was no longer owned by a husband
Well, by
and wife.
Constitution, the only people entitled to homestead are natural persons, and there's about a dozen cases, maybe more, that say, well, a natural person is also a trust.
That's for purposes of homestead, and it's clear in the case law that conveying your homestead into a trust does not affect the homestead status, but it does sever the tenancy by the entireties because it's no longer owned by a husband and wife, Your Honor. There was an argument made about Section 732.401 sub 1 only being intended to protect spouses and minor children. That's simply incorrect. This issue is controlled by King versus Ellison, which came out of the 4th District and was affirmed by the Florida Supreme Court. In that case, well, I won't go through all of the facts, but suffice to say that a decedent died with homestead and a will leaving his property to his children and his stepchildren from a former spouse, but he died with a surviving spouse and descendants, and therefore 732.401 took over. The property descended immediately with a life estate to the surviving spouse, remainder to the adult descendants in that case, and the left out children argued, they sued and said, hey, this statute's unconstitutional because look, here's all this authority that says Article 10, Section 4C is only designed to protect spouses and minor children, which is true. However, the statute was found to be completely consistent with the Constitution.
Know from the record why there was a delay, such a long amount of time passing before suit was brought? Does the record say anything about that?
It does not, Your Honor. I mean, I could tell you, but it would be extra
Either it's in the
record.
record or it's not.
Right, exactly, yes. So in any event, the 4th District and the Supreme Court of Florida both affirmed and explained that the Constitution places a restraint on the devise of homestead, but it's silent as to what happens when you don't devise the homestead or when you try to devise it, but you devise it in a way that's something other than a fee simple directly to the surviving spouse. And that 732.401 fills that void. It tells you what happens, and it applies where there is no devise, and it applies where an attempted devise is something other than fee simple to the surviving spouse, so it applies in this case. The statute of limitation argument. The limitation period is 20 years under Section 95.231 sub 2. That's the provision that was applied in Reed versus Fain that we cite. And that's it. I'll rest on
That's
my...
it.
That's it. I'll rest on my arguments, and thank you for your time, Your
All
Honors.
right, thank you. We're going to take a short recess.